Hi, I'm Greg Brown, and here are our 10 best tips for avoiding business ownership disputes. Business disputes can be costly and in some instances can be catastrophic for the owners of a business, in any type of business. Whether you operate a business as a corporation, as a limited liability company, partnership, or other business entity, these 10 tips can help your business run smoothly for decades. So, number one, owner's agreements. Make sure that you have a properly drafted owner's agreement. Now, for a corporation, it's called a shareholder agreement. For a partnership or limited partnership, it's called a partnership agreement. And for limited liability companies, it's called an operating agreement. It should identify and list out all the owner's rights and obligations. It should also include a procedure to follow if a dispute arises. If a deadlock between owners occurs, the business may not be able to operate, which could be very harmful to the business. There's much more on these agreements that you need to address, so put the time in. Okay, number two, profits and salaries. It's wise to have clear policy on distributing profits and paying salaries. If you already have written guidelines, be sure to follow them. And to determine what policies will work best for your company, discuss these issues and ideas with the other owners, but also with other professionals like your CPA. Once finalized, these policies should be implemented and followed regularly. Okay, number three, time off. Establish clear guidelines on when owners can take time off. In private companies, disputes can arise when one owner feels like they are working harder than another owner. Having a clear policy is important because owners should have the ability to take time off. This includes vacation time, sick time, or other types of leave. Okay, number four, non-management owners. Frequently, a dispute arises when an owner has been excluded from management. The roles and duties of all owners should be well documented. Who is to be involved in management? Who is only a passive investor? What are their respective rights and obligations? These roles are particularly important to clearly determine as it relates to decision-making authority, board meetings, as well as hiring and firing. Okay, number five, the interests of the company must always come first. Directors have a duty to act in good faith and in the best interests of the company. This is known as their fiduciary duties. Now, disputes can arise where a director starts putting their own interests first, which is often at the expense of the company or the shareholders as a whole. Before entering into any related party transactions, always ask yourself, is it in the best interest of the company as a whole? Number six, keep good records. Good business and corporate governance require keeping detailed records. Another reason to keep detailed records is so that there's evidence to support your position in the event allegations are made against management. Your case will be much more compelling if there are documents that are prepared over time that support your oral evidence. Providing these records to all those entitled on a regular basis can help avoid owners complaining that they're not being given all the information on the operations of the company or being kept out of the loop. Okay, number seven, communication. As with all relationships, communication is vital. The earlier and more often, the better. It's better to address issues immediately before they become bigger issues. The larger issues become, the more difficult it can be to get everyone on to the table to work it out if emotions get into the mix. Okay, number eight, use of company funds. A common allegation in shareholder disputes is that a defendant is using company funds to defend the dispute. There are instances where company funds can be used to defend a lawsuit. But when owners are involved, the issue can get really tricky. Get advice before simply using company funds to pay your lawyers. Making the wrong decision here can be very costly. Okay, number nine, succession planning. Ownership disputes may arise when there's a breakdown in the relationship between two or more owners, or if control of the company is handed down from one generation to the next. Early succession planning and regular communications between the shareholders and owners and potential future owners will minimize the chance of a dispute arising. Okay, number 10, legal advice early. What do they say? An ounce of prevention? Yes, it applies here. It's smart to seek legal advice at an early stage. Lawyers who have experience in these types of disputes have seen similar situations before and can provide important strategic advice. Avoiding a full-blown lawsuit can be the difference between a company surviving intact as opposed to suffering significant financial losses and pressures. If you'd like more information on this topic or other legal or business disputes, call us today at 714-505-3000 or email us at inquiries@bc-llp.com. Thank you.